And on inception, the drafters of both bodies of law did not explicitly envisage that the two would overlap. So in their origins, it was assumed that human rights law would apply only in situations of peace. This is the separation theory, as it's called. But of course, the founders of the United Nations and the drafters of the Universal Declaration on Human Rights had war in mind. The UN was born out of the ashes of the mass murder, the murder on an industrial scale that took place in the Second World War, and it should be noted, took place to a large extent in situations of occupation. And likewise, the drafters of the Geneva Conventions looked to the Universal Declaration to inform their work. I think probably that's most obvious for those of you who are familiar with the Geneva Conventions, in Common Article 3 to 4, which lays down the minimum standards of treatment in situations of non-international conflict. But the focus of one was on its application in peace, the focus of the other was on its application in conflict. And indeed, in 1947, the International Law Commission excluded the laws of war amongst its topics for codification, because it did not want to be seen, ironically, as undermining confidence in the ability of the United Nations to preserve peace, whilst the Red Cross movement was reluctant to incorporate human rights considerations into its deliberations because of the overtly political nature of the United Nations. But over time, these separate strands have become a little less clear, with member states of the United Nations more and more explicitly recognizing the relevance of human rights in conflict situations. So the General Assembly, to give you some examples, has invoked human rights in the context of the invasion of Korea in 1953, while the Security Council made the same link, I think for the first time. It's made it many times since, following the Soviet invasion of Hungary in 1956. And in 1967, following the so-called Six-Day War, the Security Council noted that human rights had to continue to be respected, even in those territories occupied by Israel. But it was really the Tehran International Conference on Human Rights in 1968, which is seen to be the definitive moment of, marriage is possibly too strong a word, but of these two legal frameworks really coming to be joined together. Because in this conference it was noted for the record that human rights continue to apply both in situations of conflict and of occupation. It's also the case that international human rights law itself began to recognize the linkages that it had with human rights law, not just the other way around. So the two additional protocols of 1977, the protocols additional to the four Geneva Conventions, are clear evidence of this, dealing with the protection of victims of both international and non-international armed conflicts. Because in those documents they acknowledge the application of human rights to their context. Yet another recent instance in reverse of humanitarian law influencing the development of human rights law would be the drafting of the recent Convention for the Protection of All Persons from Enforced Disappearance, which echoes additional Protocol 1, because it for the first time enshrines in human rights law the right to know what happened to a family member. Previously that had only existed in humanitarian law. And the Convention on the Rights of the Child provides another explicit example of the linkages between the two. I won't go into that. So now we have a situation where the ICRC, the Security Council, the General Assembly, the Human Rights Council have all clearly recognized the link. There have been resolutions as far-reaching as former Yugoslavia, Kuwait under Iraqi occupation, the occupied territories we've also already mentioned, Afghanistan, the resolution of the Security Council seeking to legitimize the recent occupation of Iraq. All of these make that link, as do the requests by the Security Council for certain investigations by the UN into violations of human rights in connection with conflict in Sierra Leone, Liberia, and so on. So this process is in fact accelerating. And I think you saw this acceleration again in the recent round of UN reform, which explicitly acknowledged the centrality of human rights in ensuring peace and holding back conflict. So there were calls for the High Commissioner for Human Rights to play a more active role in the Security Council, whilst there was the recent creation of the new post of the Secretary General's Special Advisor on the Prevention of Genocide, whose mandate focuses on violations of both humanitarian law and human rights law. The debate is not totally won. I think it is won, but there are still some who continue to maintain or seek to maintain that the two bodies of law cannot coexist. So this was the position of the United States when it responded to a United Nations human rights report on detainees in Guantanamo in 2006. Seeking effectively to exclude human rights law from the conflict situation. Israel, in its second periodic report to the Committee on Economic, Social and Cultural Rights, also rejected or sought to reject the application of a number of human rights treaties in the occupied territory on the basis that the situation was one pertaining to armed conflict. But I think these positions are weakening. Strengthening, I would suggest, to those who put forward the arguments of those who approach this situation in a manner which, in English, the complicated word is called teleological, which seeks to work back from the objective. The argument is developed working back from the objective which is being sought. So under this approach, it's argued that the legal framework which best serves the interests of the victims on the ground should dominate in a given situation. And as an advocate of the primacy of human rights, that's one that I'm very comfortable